where the hotel is, whether they need a stipend for food or transportation or whatever that's going to look like as part of the case. Questions? Okay, I'm going to move on to handling a case. So I just want to take a step back and talk about our client population for a second. I don't know how many of you have done pro bono work with our client population before, but I always just kind of like to level set about our client population so that if you haven't, we're all on the same page. So our clients face a lot of challenges aside from the fact that they might live in some really challenging housing conditions. We don't have an income threshold of the clients we work with. We don't have a hard cutoff for who can be referred to us, but typically our clients are low income within, 200 to 300% of the poverty line at the highest, but often, very close to the poverty line. In wards 7 and 8, about 50 to 60% of children are at the poverty line, which is very high in DC. And the poverty line in DC is about $25,800 for a family of 4. So if you make $25,801 for a family of 4, you are not in poverty, which sounds kind of like not that much money. A lot of our clients may have lower literacy levels. So I encourage you, if you don't know how to check what level you're writing on in Word, you figure it out. We recommend that you're writing to clients at no higher than an 8th grade level. You can check that in a Word document, and sometimes no higher than a 5th grade level if you're not sure. That's really, really hard to break yourself of as a lawyer. Really, really, really hard, right? Like for new lawyers, that's often the hardest skill that I'm teaching them is how to stop talking like a lawyer. So I challenge you to really think about, are you explaining this not as a lawyer anymore, and really breaking down the terms and words that you're using. Please don't mail them the retainer in the mail and wait for it to be mailed back before your first meeting. A lot of our clients find that really off-putting. We don't encourage people to sign things that they can't understand, and there's almost no way any of our clients will be able to understand your retainer, sign it, and mail it back. We always walk through our retainers and our releases with our clients so they can understand it and set up a good practice of understanding and asking questions about what you're signing rather than blindly signing legal documents. A lot of our clients rely on public transportation. So even though getting to Southeast DC might be a 10-minute car ride from this office, it might take them 3 hours to get here, 4 buses and $20 each way. So a lot of our clients, we've been doing a lot of community outreach and feedback work with our clients. And a lot of our clients in our housing cases, our lawyers actually go out and meet in their house for their housing conditions cases for their first meeting so that they can see the conditions and get a sense of what's really going on. And I think that's important for a couple of reasons. One, it gets them a sense of what's really going on in both ways, right? So it helps them appreciate the conditions, it helps them see what's going on. They can really see the mouse holes, they can see everything that's going on. But also if there are any, client counseling moments that need to happen, if, from little things like they have an uncovered trash can, like that is not the cause of their major mouse infestation, but you can bet the landlord's going to say that it is. And so I'll say, obviously, this is not the cause of your major mouse infestation, but I don't want the landlord to come to court and say that you have an uncovered trash can and that's why you have rats in your child's bed. So is there any way that I can work with you to get a covered trash can? Would that be okay? Because anything that you can do to set your client up for success without having to deal with these stupid things that the landlord might come back and say can be really helpful, right? Also, your client might really appreciate it, and it might make it more likely that the meeting will happen in a timely way, right? They're not having to worry about, they drop their kid off at 9, they have to pick their kid up at 2:30, and they have to spend 2 hours each way getting to you in the middle. That's their entire day, right? So one thing goes wrong and they don't make it to your meeting, or they don't have the money to pay for the 3 buses each way, and they don't make it to your meeting. Now, some clients prefer to come to you. They don't want you in their home for a variety of reasons, and that's fine. But if they don't make it to the meeting, don't take it as a lack of interest. I always confirm the meeting. When you first call the client, I ask what their preferred mean of communication is. Some of our clients don't like to get, the calls can be hard for them because they don't they're not allowed to pick up their phone at their jobs. They work security, they work in the mall, they work at a job where they're not allowed to answer their phone. They say, I prefer to get email. If you have an email address, ask, how often do you check your email? I check my email about every 10 minutes. A lot of my clients are like, I check my email if I know I'm getting an email. Well, that's hard to do unless you also call or text them to say they're getting an email.
I'll just say, if the family's really reluctant to have you come visit them in the home, I think that's something you want to talk to them as well about, because having a housing conditions case means a lot of people are going to be in their home.
Yeah.
They're going to have inspectors. They're going to have maintenance people, and if they are kind of skittish about that's something you just want to counsel them about. So
that's a great point.
It's kind of a good norm setting.
Yeah, that's a good point. The other thing that a lot of us have set up are Google Voice numbers. So that's a way you can have like a number to text a client from without giving out your cell phone number. It's just an app you can add to your phone. And you can text clients from that. A lot of our clients have moved to just preferring being texted. And that is a quick and easy way that you can have contact with your client. You can shut it off and on so you're not getting it at all hours of the day if you don't want to. But a lot of our clients like that. So all that to say, the other thing is sometimes a lot of our clients have Cricket cell phones that they pay by the minute. And so at the end of the month, their phone might be off, but a lot of our clients can still get texts on Wi-Fi when they're in places where they can get Wi-Fi. So they might not be able to get your call, but often they can get a text or an email. So just be flexible in thinking about how you communicate. A lot of us have landlines at work or have cell phones on contracts. And so just I encourage you to be flexible and think about how you get in contact with them both in person and by phone, because it may be different than how you are accustomed to communicating with clients in all sorts of ways. See, there we talked about poverty a little bit already, and here's the poverty scale for this year. I also recommend, we try in our intake to get a lot of ways to contact somebody, but I recommend you have that conversation again. In our intake, we've also already tried to screen for what type of housing they have, who their landlord is, right? But you should do all that again. We do all that again in our initial client meeting, and you should do all that again in your initial client meeting. Be like, this is the information I got from your intake. I just want to make sure it's all correct, that your no phone number hasn't changed, that there wasn't a typo in your email, right? Like, we do our best, but goodness knows I've certainly written down people's emails wrong, and then I get so frustrated that nobody emailed me back but I'm emailing like styled 78 instead of styled 87, right? Like, do they have a backup number? Could I get their mom's number in case their phone goes out? Like, is there someone else I could call? And then is there a regular time they'd like me to contact them? Do they work? What are their work hours? Is there a best time of the day? Is there a time of the day that's always bad for them to contact them? Just so that you have a sense of when is a good time to be in touch, just to make contact less frustrating or better and for everybody. And then when do you want them to contact you? What kinds of things? Do you want them to call you every time their landlord calls you? Do they want to be the one always in touch with their landlord? Do they prefer that you be the one taking over some of the contact with their landlord? Do they have a very adversarial relationship with their landlord? Like, I think you want to get a sense of some of that and establish some of the sense of, maybe you want them to continue to be making maintenance requests, but you want them to now be doing it in writing and keeping it in a notepad that you brought them from your office, right? You want them to write down in their phone. They're going to text you every time they make a maintenance request. So now there's a written log of all the maintenance requests that they made, right? So you want them to keep in the practice and build that advocacy skill for themselves, that they are making written requests for maintenance and keeping a log of it. But you're going to follow up with the attorney about it, right? So what are your different roles going to be? Because they've been doing this all themselves. And maybe all they've ever done, because all they've ever been told to do is call the hotline where they leave a message, and nobody ever gives them any confirmation that anybody ever did anything, right?
I will say that, again, this is like a good norm setting moment. So you're not going to have their case open forever. Hopefully they're going to continue to live in that property for however many more years. So I always counsel my clients, like, my goal is to fix the immediate issues, but also to help come up with a way for you to work with your landlord going forward. So I do not want to become your receptionist. I do not want to be in the middle of scheduling if it's really not needed in this situation. So I think it's just, this conversation is so important if there's going to be ongoing repairs and you're going to be trying to figure out what time the plumbers come in, and that's going to be your job for the next 2 months. Like, these are important things to discuss.
Right. You may consider offering assistance if you're able to with transportation to your office if you've decided that the meeting's going to be in your office or that you're going to go to them. And then if you do lose contact, we're happy to talk to you about what to do, but you may want to follow up a few times. You may want to send a letter. A lot of our clients report they don't check their mail, get their mail, open their mail. So sending a letter shouldn't be your only means of trying to reach back out to them. But we do typically mail a letter in addition to also trying other means of getting back in touch with them. We talked about this a little bit, but don't use legalese, written communication at an 8th grade level. And again, don't mail the retainer explaining stuff in person. If it's a really big problem that your firm always mails the retainer, we're happy to touch base with you about it. But at the very least, if you have to mail it, schedule a call to go over with it. I have read legal retainers and I can't understand them. So there's just no chance our clients are going to. I think the other thing that clients have really always consistently raised to us as we talk to them about this process and they give us feedback on it is just recognize there's an imbalance of power, right? Like you hold the keys to fixing this problem in their eyes. You hold, in their mind, right? Like you hold the power and in a lot of ways, but actually they're the boss of the case. So I always tell clients, right? Like my role is really strategy. Like I understand the law here, but you're the boss of the case. That's what a client is. A lot of clients, even if they've worked with lawyers before, no one's ever said that to them, what their role is in the case. You decide the goals. You're the one telling me, do you want to go to court? Do you want to take this next step? My job is to try to figure out the best way to get to your goals. And I'm not going to be able to do that without you directing that case. So that's important because my only role is to help you get to your goal. And I'm going to need to be in touch with you regularly to get direction from you about how you want to get to that goal. I often end the meeting with sort of a written to-do list of my next steps and their next steps. So your next steps are going to be reaching out to the landlord. You're going to contact me in these situations. I'm going to write a letter to the landlord with these outlining these things and what we want from them. I'm going to send you a copy of the letter and I'm going to text you next Tuesday or whatever it is, right? Just so that we feel like we're both leaving the meeting with an understanding of what the next steps are. And a lot of the surveying and feedback we've gotten from clients, like they feel like at the end of these meetings, they don't understand the next steps. Even though we think we've been really clear, they don't think we've been clear. Because think about going to a doctor's appointment. Candace left so I can say this. I oftentimes leave and I'm like, I totally understood that new medication. I'm like, I leave and I'm like, I have actually no idea. What was I supposed to take it with food? What do I do if I skip a dose, right? Like, you thought you understood in the moment and you don't. And it's the same way with these kinds of meetings. They've just spent an hour or 2 hours meeting with us, going over the law. And it's just really overwhelming. So leaving with something written is a great way to help them remember and think about it. Okay, working up your case. One other great reason to meet at their house is you can get some really great photos, right? So we often bring investigators or and law firms often bring paralegals. But honestly, if you're a solo, you can take the pictures yourself because your client can always testify about the pictures. You can also coach your client about how to take pictures because having a picture with no scale or having a picture without taking a picture of the whole room to get a sense of what room it is isn't that helpful, right? Like if I just take a picture of this hole right here, 6 months later, no one's gonna be able to know where it was, how big it was, what room it was in or what it was, right? So being able to really create an inspection report that says like this was in the bedroom, here's the whole wall, so you can get a sense of the scale, here's a tape measure next to it, right? Really documenting what it looked like and then what it looked like over time. So coaching your client that like every time they come to patch the hole, take a picture of the hole, and then if the hole comes back because the mouse ate back through it, take another picture. Or if you're not there when the water is pouring down from the toilet above, take a video of the water toilet pouring down, whatever it was. And then think about if you need any supplemental reports, making it clear if you're hiring inspectors that you're bearing the cost. A lot of our clients, I'm like, we're getting a mold inspector back. I can't afford that. And you're like, oh, no, I'm not asking you to pay for it. We've tried to always look who the landlord is. We send it to you for conflict information, but again, it's worth you double checking that information. Sometimes I want to just talk about property management companies really quickly. Sometimes landlords hire property management companies to handle all of their litigation. So you need to know who the landlord is. They have the ultimate legal responsibility, but in court, you might only ever see the property manager and the counsel that they've contracted because they have often been hired to essentially be their agent. So it's important sometimes to know who both of those are. And sometimes our clients have no idea who the landlord is. They've never done anything with them. The property manager's on the lease. We still need to know who the landlord is. And I'll sometimes name both people in the complaint because the property manager is the one that signed everything. The company's the one that signed everything. Like Edgewood, for instance, is a property management company that signs everything, but they may not be the actual owner of the property that the client lives on. We send a demand letter. There's some samples in the packet that you have. They're pretty straightforward of like, fix this stuff in 10 days, we're going to sue you, right? So it's pretty straightforward. For mold cases, we often send the demand letter and then have the inspector come out so that we've given that 7-day notice in case we ever want to get reimbursement. If it's really bad or the landlord has done bad repairs on the mold before, sometimes we'll just send the mold inspector in before the demand letter because we don't want to risk the bad repairs. We might do that in other situations where there's been bad repairs also. If we're filing a temporary restraining order, we don't send a demand letter. Usually we'll just go in and do it. And Typically, we don't place cases that need TROs because often firms can't get in on them quickly enough, but sometimes TRO issues arise during the course of a case, and we're always happy to talk to you about that if it happens. Most commonly, those are no heat comes up, like you're in the middle of a case and all of a sudden their heat goes off and the landlord's like, oh, that's so sad. And you're like, okay, you got to turn the heat back on. You're like, we're going to file a TRO, and then they show up for the heat. So you heard us talk about DCRA. Okay, I can keep going. So I'm not going to spend a lot of time talking about DCRA. If you want our CLC's official true opinion of DCRA, I urge you to read our 7 testimonies about how terrible DCRA is from the last year on our website. We think the DCRA court inspector, who's associated with Housing Conditions Court, we'll talk about in a second, is awesome. We don't use this process at all. So DCRA is the official DC government agency charged with housing inspections and code enforcement in DC. I will sum up their work with saying that we don't use this process because they may or may not come to this inspection, and at their official city oversight, they could not testify if they did any enforcement or how many fines they collected from enforcement, because we don't know if they do any enforcement. Yes. So our clients have sometimes gotten reports, and so then we'll get copies of the report to see what they found. But we find that the level of inspections are very inconsistent when done outside of the court, and they may or may not have found violations. Maybe they did, maybe they didn't. And so the reports are so incomplete as to not be helpful because they may not have found violations we know exist, and then the judge will say, but they weren't on here, so they weren't there. The one time they're useful is no heat. They sometimes will go out on the same day, and then the landlord will turn back on the heat. But other than that, we tend to steer clear of them. Like I said, you can read our testimony. This is how the process should work in theory. I'm not even going to spend a lot of time going over how it should work. DCHA inspections. I flag it because DCHA will inspect all voucher properties and all public housing annually. So our clients will mention that. We can get copies of those. There's information about how to get copies of all these reports in your manual. We just get that as part of the documentation process if we know that these reports existed at the beginning of the cases to see. These reports, again, are not proof of housing code violations in and of themselves, but can be useful in court to show that a condition existed. So if a landlord was cited for mice a year ago, it can be hard for them to come into court and be like, we had no notice there was a mouse problem. DCHA cited you a year ago. What's your problem? Of course there's mice, and you knew it. There's a lot of pros and cons with getting DCHA inspections. I typically don't bring them in voucher cases. I will bring them in public housing cases for transfer purposes. We have a lot more information we can share in some of the public housing cases if you get involved, because they've actually been doing their own levels of inspections, which Evan mentioned. There's a reading list included with this round of pro bono materials, and there's a bunch of the recent news coverage about DCHA in there that I put in there. They vacillate on the numbers, but about 2,700 of their units, they're seeing major repairs that are unsafe for tenant habitation. They're estimating they need $343 million next year and $1.2 billion over 10 years to keep their property habitable. So that is what it is right now. But we, needless to say, have a lot of DCHA housing conditions cases. We do a lot of fair housing requests or reasonable accommodations requests encapsulated in these cases, which Evan mentioned. And we have the DOJ HUD joint guidance within the manual that's worth reading if that comes up in your cases. It most often comes actually related to a question you asked earlier with service animals and emotional support animals. Sometimes we will find that they have a pet that was recommended by a therapist, and the landlord's like, well, we're going to evict you because you've had this pet for 5 years and you've never done the formal documentation for it. So we'll actually sometimes help them just do the formal documentation for it to get it approved as a side thing in the case. It wasn't what the case is for, but we'll sometimes get it approved that way. And then I have a number of cases I'm working on right now that are like kids that have become disabled while living there that need like a transfer to the first floor or need, other accommodations made there. But those are typically not. If you're interested in that kind of case, we do have those kind of cases. It's not typically what we place pro bono. The removal of carpet is probably the other big piece because that's not a housing code violation, but for a lot of our kids with asthma, it can be something. The reasonable accommodations piece of it, there's a weighing standard of whether it's an undue burden for the landlord to have to do it. So for people with public funding with the subsidies, DCHA, the project-based Section 8, they're much more likely to have to remove the carpet than somebody who just owns like a single property. Especially if there's no flooring underneath it, right? To have them build a floor for somebody is a much bigger deal than just ripping up carpet where there's already wood flooring underneath it. A lot of times we find there used to be wood flooring that rotted away because of the water damage that caused all the mold. So that can be an issue. But we're frequently able to get people transferred to a unit without a carpet rather than rip up the carpet in their current unit. Sometimes we're able to get new fresh carpet, like we negotiate an outcome, and we're able to get new fresh carpet with like regular cleanings rather than no carpet. Or we're able to just get new fresh carpet because the carpet keeps in all that like the mouse stuff and the cockroaches and right, like all that infestation stuff of it. You also want to think about sequencing. Don't replace the carpet before you fix the mice, or there's no point of replacing the carpet, right? And then sometimes we're able to add an extra bedroom, right? So I have a case right now where the kid has so much medical equipment, they actually need to hold their bedroom to store all his medical equipment because he has a walker and a stander and a wheelchair and a special hospital bed, and he can't share a room with a sibling and kind of all of that stuff. So we got an extra bedroom added to the unit. So there's stuff you can think about if it comes up, and Evan and I and the other housing mentor are happy to talk to you about it if it comes up. All this is really just stuff for you to have in the back of your brain of like, hey, they said something about it. Maybe we can help with that. Remember when I'm transferring to you?
I can talk about this.
All right.
Yeah. Okay. So DC is different than most jurisdictions in that we have two types of housing court. Tenants may be familiar with landlord-tenant court, and that is not the court that we raise housing code violations in. We raise those in a separate docket called the housing conditions calendar. So the distinction is landlord-tenant court is eviction court. That's landlords suing tenants to evict. Housing conditions calendar is solely tenants suing their landlords for housing conditions. So important distinction. Other places we may file would be a civil case or a small claims court. We see small claims a lot kind of on the back end of our cases. So we've taken care of the flooding issue or the mold issue, but in the process, the family had to throw out all the furniture and get new furniture. And so maybe on the back end of the case, we're going to help them get reimbursed for that furniture they had to replace.
And just to clarify, you guys could or could not do that as pro bono attorneys.
Yes.
Some of our pro bono attorneys have wanted to do that, and some of them have said like, we'll give you back to CLC and they can give you advice or handle that. So you're not on the hook to do any small claims, but some have been like, this is so wrong, I really want to do it. And we're like, great, go for it. So up to you.
Yes. But primarily our cases are going to, if you end up in court, it's housing conditions. So we're going to talk about that. So what to know about the housing conditions calendar. So it is a calendar within civil court. It's, like I said, just tenants suing their landlord. So it's an affirmative action. So historically, a lot of our tenants were advised, withhold your rent, wait to be sued for eviction, and then you'll end up in landlord-tenant court. We do not generally advise that anymore because then there's a case where they've been sued for eviction that looks bad in the future if they're applying for other housing. So this is alternative to that. This is an opportunity for them to affirmatively go into court and get their issues addressed. The court is very restricted, so they don't want to talk about money. They will not talk about back rent that's owed. They won't talk about that dog you had that's not supposed to be there. They won't talk about extra people on the lease. They will say, we are a fix-it court. We are here to fix the housing code violations. You can, landlord or whoever, can raise all those other issues somewhere else. I don't want to hear about it. There's one exception to that, and that is if we're going to court like month after month and the repairs aren't being made, we are able to get a remedy of prospective rent abatement. So landlord, you're not going to get paid rent until we end up in court again. So don't pay April rent, we'll be back on April 30th, and if the violations continue, they're going to continue to not pay you rent. But that's kind of the limited circumstance where we'll talk about money in housing conditions court. Otherwise, we're not going to talk about it at all. So there's very basic forms to fill out to end up in housing conditions court. These are all available on the website. It is designed as a pro se court, so they are pretty straightforward. Most of our clients end up qualifying for an IFP. those forms, again, are also on the court website. They're also all available on our materials. I think we're going to talk about something else, but they're also, and then for TROs and preliminary injunctions, we often draft our own. Their forms just aren't very detailed or don't allow you to kind of spell out what you're doing. E-filing. So they're using Case File Express more for housing conditions court, but if you have an IFP, it becomes very complicated. So feel free to talk to us if you end up in that bucket, but you can always hard file. Okay, so a TRO. So like Kathy mentioned, no heat. Heat is not required when it's not, your heating system doesn't have to work in July. So we're kind of in this moment right now where landlords are like, well, I'll kind of fix the heat and maybe it'll last for 5 days and that'll get us to the 70-degree weather and then we'll be fine. And we kind of end up in this bucket where we're going to have to wait till November to fix the heat because you're not able to show that it's cold in the unit. Constructive eviction, obviously, if the family is not able to live there because there's water pouring from the ceiling regularly, that could be a reason for a preliminary injunction. The court is handling these in all kinds of different ways, just depending on who's the judge in chambers the day that you try to go in. So some days they're willing to hear the case that day. Sometimes they're setting it on the housing conditions judge's docket, but for a different day. So they're like, Judge Epstein, here's all these. He's going to hear this one. Normally, housing conditions court is just Tuesdays. So they may say, we'll set it for Tuesday, the next upcoming court date on Tuesday. So you may get a wildly different experience just depending who's there the day you file. But the goal, obviously, is to get this addressed quickly. So if you're not filing a TRO, this needs to be updated. It's not Monday morning anymore. It's Tuesday morning. So housing conditions court is always on Tuesday morning now. It's a cattle call, just like landlord-tenant court. So there's usually, I'd say, about 30 cases. 9:30 are all the initial hearings. 10:30 are all the status hearings. When you file, you're usually getting a date for 3 to 4 weeks out, I would say. We're serving, the court will serve the landlord when the client has an IFP. And in pro se cases, that's usually fine. We usually don't let to just rely on the court because they'll just send out certified mail. If they get nothing back, now we're just, we're just waiting around. So we usually take care of that for our clients. You'll need to find registry agents for any corporations. And I would say we're always trying to file the affidavit of service in advance. If the client or if the landlord's represented, I would say 99% of the time, the attorney comes to court and they say we accept service and it's not usually an issue. But if they're not represented, it can be an issue. So that's something that we really ask the attorneys to take on behalf of the client. Okay, so the court date, the initial hearing, we usually bring the client along. The first court date is very procedural. So there's a DCRA inspector who's embedded with this calendar. They are in court every Tuesday. They just sit there the whole time. And they are the DCRA inspector that will come to the client's home. So they will schedule the inspection. It's whenever they're available. It could be next week. It could be in 3 weeks. Just depends. Usually, we're not able to get a lot done until that inspection happens, unless you're able to bring some pictures or some hard evidence of what's actually going on. The current judge is a little bit skittish about doing too much until the DCRA inspector takes a look at what's going on. Generally, this is treated like a settlement court. It's pretty informal. You're not probably going to get a written order unless you specifically ask for one. And in that case, we usually recommend bringing a draft order for the judge to fill out right then. Right, so the inspector's going to go out. We recommend sending somebody to be there with your client, particularly just because they can not remember all the different things they've pointed out to you previously. So you just want to make sure you get a thorough record of all their concerns. This is going to be the definitive list of what needs to be fixed. So you really want to make sure that everything that the client is concerned about is raised during this inspection. The landlord usually brings a representative as well. The inspector is available to you to just email informally afterwards if you have questions. Hey, you cited this thing. How should that be fixed? Or were you talking about the left bedroom or the right bedroom? Any questions you have about the report, you can really just circle back to the inspector. And then you're just going to have status hearings from there on out. Again, very informal. It's just going through the list. Here's issue 3.1. This has been ameliorated. 3.2, the current status is they're ordering window screens and those haven't come in yet. And just going through those and any disputes about that. But it's really referring back to that inspection report. So you want to make sure that if the inspector got something wrong, you're getting that corrected because the judge relies very heavily on that. So I would say our cases, it takes 3 to 4 weeks to get your first hearing. It takes probably, you have your second hearing, maybe another month after that. So, some landlords are motivated just by you filing. Other landlords need a little more encouragement. So our cases last in court anywhere from, I'd say, about 3 months to, up to a year in an egregious case where there's ongoing issues. So ways that we can actually get things moving. If there's a dispute, so, we've got warring mold experts, we've had pest control disputes where we've had pest control experts. You can actually ask for an evidentiary hearing about what actually needs to be done or how it should actually be ameliorated. And then sanctions, prospective rent abatement is another good way to motivate the landlord to get the problem fixed. In general, not going to have an evidentiary hearing and not going to have any sort of real trial unless you're having like a war of experts.
Do you guys have questions on handling cases? Court? Any of the fun stuff we've talked about so far? Yeah. So the question is, do we have mold remediators and contractors to donate services? We do not. We pay for. So we don't pay for the mold remediators. We litigate. We don't. Yeah. So we pay for the mold assessor. We typically use and recommend somebody one person we typically use the most frequently. But the landlord pays for the actual work to be done because that can be quite costly. It can range anywhere from a couple $1,000s to $20,000 depending on the work that needs to be done, and the landlord does pay for that.
And I will say the judge is never sympathetic to the financial situation of the landlord. So they will say, like, you take out a second mortgage, get a loan, I don't really care. You decide to become a landlord, therefore you must, follow the housing code.
And like our clients are, paying their rent, so they expect the landlord to hold up their end of the deal.
Yeah.
Mm-hmm. In the court report? Yeah, so the question was with the DCHA inspection report we get from the court, does that trigger repairs? In some significant number of cases, it does. So when we get that report from the court, like through the court process, that actually does trigger resolution in a significant number of cases. I think the biggest issues are the real slumlords, who we do have in a bunch of our cases. And if it's mold where the DCRA doesn't inspect for, and sometimes it's about the type or quality of repairs that they do, which even DCRA will come back in and be like, so you say you repaired this, but if I touch it, it falls down, right? So it might be that kind of issue also. Go ahead. Yeah. Have we seen rent abatement on a Section 8 voucher?
So I had a case where the tenant paid $0 as their portion of the rent. My legal research made me believe that we could get an order, but we did not succeed in court on that argument.
So the problem with if you do that is you have to notify DCHA or HUD, and they have the right to intervene in the case and collect the rent abatement, and they actually will do that. So we usually don't ask for rent abatement where our tenant is a zero renter, but some of our tenants are zero payment renters, but often with subsidized rent, they're still paying something. So we'll often ask for just their portion of the rent to be abated, whether it's $100 or $25 or whatever it is. And honestly, the judges in where our client only pays a small portion are even more likely to abate, because to them it's like, oh, it's only $100. You know, like they may be more likely to abate for those also. Someone over here had a question too. Yep. Do we see the same landlords over and over? Yeah.
Well, we see DCHA a lot. They are one of the biggest landlords in DC, and their housing stock is just old and falling apart, and they haven't been funded to fix a lot.
Yeah.
So you see them, and when there's a couple, there's a couple high flyers.
So we do. So we actually are part of. We have some funding through a national award called the Build Health Challenge, where we're one of 19 cities funded to look at actually decreasing the asthma disparity. And our partners are Impact DC and the DC Department of Health. But part of what we're doing with that is mapping and looking at some of like the big slumlord landlords. And one of the things we've identified is some of the really big slumlords. And our Office of Attorney General actually has a housing and community justice practice that has started in the last 2 years under our current Attorney General, Kari Seen. That's amazing. And they're doing affirmative civil prosecutions where they're bringing receivership actions against some of the biggest slumlords in DC. And they're getting the whole properties put under receiverships for tenant housing condition abatement. So 4 of our long-standing really bad properties are now going through that process where they are either getting receivers or have had receivers appointed. And the landlords are no longer in control of the properties at this time, and they're being forced to put money into accounts for the receivers to abate the conditions. So we've been able to funnel client information, get clients to talk to the OAG and sort of point the OAG in the direction of some of those. And that's been a really invaluable resource because we don't have the resources to bring those kind of cases, or the legal authority, but mostly the resources also, to bring those kind of big systemic cases. And so that's been a really nice tool to be able to identify, for instance, Forest Ridge, the Vistas. We've had dozens and dozens of cases at this project-based Section 8 properties over the years. And now they're the subject of a major receivership action where a receiver has been granted, it's hundreds of units at the property. And now there is a receiver appointed that's going to start making repairs at the property. So that's it's not the be-all and end-all of tools, but it's one of the tools that we've been able to sort of push some of the really, really bad landlords that direction. No. Do we ever deal with retaliation? Yeah, do we ever deal with retaliation? I think in our immigrant cases, that is actually a really big concern. And for a lot of our immigrant clients, they don't want to litigate. So often those are not ones that we place pro bono because they're not interested in litigating at all. Our attorneys who are at Mary Center and Unity do a lot of client counseling to even if they want to work with an attorney at all, especially in the immigrant climate we have right now in the United States. A lot of our clients are very, very hesitant about going to court for any matters, even if they're totally in the right. And a lot of the landlords we're hearing, not a lot, but we hear threats that landlords make about we'll call immigration on you. Or some of our immigrant clients are living, a lot of people in one unit, and we may advise them, like, if you do that, you risk eviction. So maybe we should try to negotiate, or maybe we should try some other strategy because you do have 10 people in a 2-bedroom or, whatever it is that might be out of compliance on their side. So there's other things to think about there. But I think even more than being out of compliance, like a lot of our clients are just afraid about the immigration climate. And we also have clients who have been homeless for a long time, and housing they're just happy to be housed. And so it may not even be their top priority. Like they also have a lot of other legal issues going on or a lot of else going on in their lives. And so they want to get this solved, but they also need to get a job and get everything else solved. So it can be really challenging. Yeah. No, go ahead.
I would say, so the timeline from the first court date to inspection, it's really just dependent on the availability of the inspector. I would say approximately between 1 and 3 weeks. 1 to 3 weeks. It just really depends on the inspector's schedule.
But it's pretty quick.
Yeah. And sometimes like you can be strategic about whether you want to push the inspection really fast or to actually, they're working on repairs and maybe they're going to get all the repairs done and you're going to treat that inspection like a final inspection. And so once the inspector comes out and says, actually everything's been abated, you're going to use that to then counsel your client. It's time to dismiss the case. So it's just kind of deciding what things are. Yeah.
From the court date. The subsequent court dates are set from the first court date. So you're there, you set the inspection, and then they set the court date pretty soon after the inspection date being set, so that you can come back to court to review the inspection and kind of create an abatement plan from the inspection. So the materials that you have are on the flash drives and also are on our website if you lose the flash drive. Though I think the flash drive is easier because you get the individual documents listed of large PDFs. But so that if you're thinking of like, I wish I had a sample of this, we hope that we brain dumped everything onto there. So hopefully it's there, but if it's not, feel free to reach out to us. And I know Jenna's gonna talk a little bit more about what's out there and how to get cases.
Yeah. We are at the end. Thanks so much, Kathy and Evan. Again, lots of information. The idea for today is to gain some familiarity, know where you can look through the resources and materials that we have. So yes, the flash drive is our training manual. I said earlier this morning that that table of contents for that manual is number 4 in your handout. So what now will likely resonate a little bit more as you look at it. And I'm not going to read through all of this, but we have sample client documents, some releases that you might use with your client. We have references to the law, so you're going to see some of the codes, as well as the mold law and different related things that you heard about from Kathy and Evan. How to request different records. You're going to see sample requests for reports. That's included here. Health hazard information. You're going to see some things about asthma triggers. So of course you were hearing different things from Dr. Dawes today, but we also included some other information. There are particular requests for reasonable accommodations. So that may or may not come up in one of your cases, and that's something that we're generally flagging on the front end so you would know. Litigation documents, so you're going to see HCC, Housing Conditions Court. So of course, acronyms are still following us. You'll see a complaint in here as a sample as well. So you can check these things out. IFP, Informa Pauperis, so our clients, low income, that is a filing related to that. And so you're going to see that material in here as well. And also some tips, client advocacy. You know, ultimately, Evan mentioned this earlier in terms of, I can't remember the words you used, Evan, but like the norm setting maybe, you know, when you're first meeting with your clients. In all of our cases, we are trying to help with the legal issue, and we're hoping that we leave our clients better off, right? That we're actually achieving success, we're achieving the client goals, but we're also doing some empowerment there and some teaching so that clients are able to, in subsequent, you know, issues that might arise, be able to do things on their own as well. So just keeping that in mind. Those cases that we have, again, there are 2 of them listed on your paper for housing conditions. And the first one, there's a 9-year-old girl who has asthma. Again, we see a lot of that. We are concerned about the mold in the home impacting her health. And so we had great questions about kids being out of school for how long when you're going to the doctors. These things are serious and impacting the families that we're working with. The second case, we've talked about rats, we've talked about mice, we've talked about all sorts of things. So this isn't a lunch training. Is that on purpose? You know, think about it. Yes. So in this case, we had a rat that crawled into the child's bed and bit her. So she went to the emergency room for that. The case that I just got last night that also has rats, they're just crawling all over the place. You know, the kids are having reservations about even eating because they're everywhere. So these cases, they matter. And I think that you all have taken that away. And I just want to wrap up by saying you can help you definitely can do this. Your other takeaway is probably getting a new pillow or pillows if you haven't done that. That is always something that I'm reminded of whenever we hold these trainings. So thank you for coming. Thank you for listening. If you have questions about the cases, no pressure to be taking something if it's not the right time. But if you're interested and want to help out, we are looking for lawyers in all of these cases, and we're happy to answer your questions. So feel free to chat with any of us on your way out today, or shoot us an email. Our contact information, my contact information is just about everywhere. And we appreciate your time. So my last final request that I leave you with is to complete our training survey. Was there anything that you think we should have touched on more or less? Do you think this training is long enough or too long? Anything and everything. We really appreciate the feedback. And it is a front and back survey. You can leave it with me or Alyssa, who's in the back. So thanks, everyone. Enjoy the rest of your Tuesday.